2006 to 2023, which means that we are about to get schooled on the current practices in Tanzania today. We are also joined by Ms. Jackie Oyuyo-Githinji. Ms. Jackie Oyuyo-Githinji is very well known in arbitration practice. She's the managing partner at Umsizi LLP and has considerable experience in broad range of corporate, commercial, and family matters from her over 25 years of experience. As a chartered arbitrator, I don't know if you had that correctly, Jackie is a chartered arbitrator. Congratulations to her once again. She has served as a non-executive director on various boards and is presently Jackie, I'm not sure, is the term over? The chair of the Nairobi Center for International Arbitration and the non-executive director at the Strathmore Dispute Resolution Center. So Jackie, of course, has played a critical role in the development of the national policy of ADR in Kenya and has been regular in discussions over arbitration, ADR, and ADR practice. We also have Anne Namara Musinguzi, who's an advocate of the High Court of Uganda with over 15 years experience and is the managing and founding partner of Namara Musinguzi and Company Advocates, which actually specializes in arbitration, construction law, and corporate governance. Anne is a thought leader in the arbitration and construction space and continues to continuously publish articles in that regard. And you will notice that she has been very sought after in several conversations across the year. You will not miss her in different conversations about ADR. She's also the director and head of faculty in the Construction Law Institute, which is an organization that is engaged in research, training, and ADR. In the construction space in Uganda. And Anne is also heading the Education and Training Committee of the Chartered Institute of Arbitrators chapter for Uganda. And she's the editor-in-chief of the quarterly chapter paper. Our fourth panelist is from Tanzania again. And from Tanzania, we are joined by Mr. Koyugi. Mr. Koyugi is a co-founding partner at the law firm of Aki P. Law. And he brings to the firm vast experience and expertise in labor, tax law, international trade law, and commercial litigation, where he has acted and provided legal advisory services to several domestic and multinational companies. Now, Mr. Koyugi has actually been at the center of a number of tax disputes, and we know now that there are very many arbitration, mediation processes of different tax disputes, and we hope he can mention something about that, whether there is any leading case in the mediation of, following the mediation of a particular tax dispute. And he is also in corporate governance and practice, which is also something that, interestingly, Jackie also does. And he has been pivotal in the provision of legal advisory services to clients on a host of legal issues. And we are lucky to have all of them here today with us to help us take a snippet, or rather to review the different cases that have been delivered in East Africa in the year 2025. Now, to start us off, and I'm hoping that Justice Gonzi, you are now settled and you are able to begin the discussion by discussing at least two cases from Tanzania. Justice Gonzi? Justice Gonzi, if you're speaking, then your microphone is on mute. Okay, maybe he's still getting set up. Jackie, over to you. If you can start us off from with a Kenyan perspective, we would really appreciate. Kindly turn on your camera and your...
I'm not currently unable to turn my video on. If somebody could assist with that.
Just a minute.
Thank you.
Eddie, can you assist me with that? I seem not to be able to do so. Eddie or Jocelyn, if you're there, please help us in turning on the video. But Jackie, in the meantime, I would suggest that you start us off.
Okay, so let me start then. Is somebody else speaking?
No, go ahead.
Okay. Let me start by clarifying my introduction because you did raise the question as to whether I'm still serving as chair of the Nairobi Center for International Arbitration. And the answer is no. My term ended about 2 months ago on the 6th of October 2025. With that clarification, then let me start us off possibly over the next 20 minutes discussing two specific cases from the Kenyan Court of Appeal, which is not quite the apex court. We still have the Supreme Court, that is the apex court here in Kenya, but these cases will nevertheless be definitive cases in Kenya at the moment from a 2025 perspective. So let me start with the case of Sogea Satom and another against the Kenya Airports Authority. This is, and the reason I'm starting with it, it's a foreign arbitral award that was not delivered in Kenya, but nevertheless was brought to Kenya for recognition and enforcement. And perhaps I should preface my comments by mentioning that Kenya is in fact signatory to both the New York Convention and the UNCITRAL Model Law on international commercial arbitration. So with that background in mind, then I'm sure all the participants would appreciate that Kenya's Act, the 1995 Act, as has been amended from time to time, is largely reflective of the principles of both the New York Convention and the Model Law in terms of recognition and enforcement, and also grounds for setting aside arbitral awards. I think the overarching message that I would want the participants to take out of this particular case is the finality of awards. And if you're a practitioner, then the need to make sure that your award is in fact final. And I think there needs to be a healthy appreciation by any practitioner of the difference between an interim award, a final award, a partial award. Two of those things are actually final. A final award obviously is final. A partial award should be final. But to the extent, as in this case, that the arbitrator fetters their own jurisdiction, if you will, by not completing the award, by dispense with all the issues that it needs to dispense with, then to that extent, it could be challenged on the basis of the grounds that we are familiar with. So a quick overview of the facts of this particular case. The award was brought before the Kenyan courts under Section 36 of the Arbitration Act 1995, essentially to recognize and enforce an award that had been made by the Permanent Court of Arbitration in Mauritius. So important to understand that in this instance, the juridical seat or the lex arbitrae of the dispute was Mauritius. And as I said earlier, this was a question of recognition and enforcement. Now, for various reasons, and this was, as is common in various construction disputes, this was a multi-phased or multi-tiered type of dispute resolution in the sense that some of the disputes had already been brought before a dispute resolution board, which had pronounced itself in terms of quantum on specific certificates, if you will, for completion. However, those were not honored by the respondent, and they were therefore then became the subject of the arbitration that was brought before this particular tribunal. That tribunal also then decided to look at the issues in a phased approach. And this is what we commonly refer to in arbitration as bifurcation, which is perfectly acceptable. You can actually just say, this particular issue is fairly easy to dispense with, and we can conclude it by way of a final award, which, because it doesn't deal with all the issues, is a partial award. However, it is final as to the specific issues that it dispenses with in its own sense. So the parties had agreed 3 phases, and as a result of a partial award in phase 2, then this partial award was brought for enforcement in Kenya. However, the enforcement of that award was challenged on the basis that it was in fact not final, not so much by definition, but in terms of the award then reserving the question of costs to a separate, if you will, quote unquote, authority. The arbitrator decided that the question of costs would be determined either by the parties in agreement or in a different way. And actually, that is what was the Achilles heel of this award, if you will, because the courts then said, how is it that the arbitrator is presuming to pronounce themselves on a question that essentially is a quantum question, but is not fully addressing the question of costs and leaving it to an authority outside of itself to determine the question of costs? So unfortunately, to that extent, then the Court of Appeal agreed with the respondent in this instance that that was not, in fact, a final award. So, whereas it was cloaked, if you will, with all the machinery of a final award, partial as it may have been, the arbitrator himself did not fully dispense with the questions before the tribunal on that particular phase of the dispute. So to that extent, then the court declined to recognize and enforce. So what can we take away from that as arbitrators? As I said already, if you decide to bifurcate issues and dispense with them in a phased approach, make sure each phase deals with all the issues in that phase with finality. In other words, nobody is coming to save you. Nobody is coming to swoop in and deal with those particular issues on behalf of the tribunal. The tribunal must dispense with those issues, or lead them to a subsequent phase if they're not yet able to, or simply not bifurcate. The whole point of bifurcation is this is a fairly straightforward issue number one, so we can dispense with it quickly and then move on to the other issues. So unfortunately, in this particular instance, the arbitrator shot themselves in the foot. Of course, there were other questions that were raised, and it's typical, I think, in almost every challenge of an award or even recognition and enforcement of award for people to throw in public policy. I almost feel like it is now the thing that is becoming the AOB of challenging recognition and enforcement of award, or even the setting aside of awards. And I think the reason people fall to it is because it is actually quite amorphous. And when I discuss the second case, I'll go into this with a little more detail. But to the extent that in every jurisdiction, whether it is a convention state or not, whether it has fully adopted the UNCITRAL model law or modified it to some extent, the question of public policy is always a question for the national courts. The national courts have their own mirror, if you will, of what that particular country considers public policy. And it will differ from state to state. There are countries, for example, where the question of interest will be a question of public policy, simply because those countries do not recognize interest as a question that should be considered, whether by a court or by or through alternative means of dispute resolution, including arbitration. The question of interest does not arise in commerce in those jurisdictions. In Kenya, for example, we talk about the national values that are enshrined in the Constitution. I'm not sure in East Africa currently, and my brothers and sister on the panel might have similar alternative views, whether even as East Africans now we are clear on what our value systems are, even before we distill that into national values and the questions or the ideas we have of morality and justice. I'm not sure that we are still moving in the same direction, even as individual states, let alone a region, in terms of what those things mean to us. So the question of public policy is always thrown in, I think, by any advocate worth their salt when they bring an award for challenge. So in this particular case, counsel had contended that the enforcement of their partial award would in fact contravene public policy. Why? Because the respondent was a state corporation, and if they were forced then to pay damages on quantum that is not yet ascertained, then that would almost amount to a waste of funds that are public funds in nature. And in so doing, then they would be sort of depriving the Kenyan public of resources that could actually be utilized more effectively elsewhere. Unfortunately, that question, of course, was not considered fully in this particular issue. But I think because the court had already directed itself and said that they were not going to recognize the partial award, they did not consider it a partial award, then the question of public policy was not also conclusively determined. But I think there are several cases, nevertheless, and I'll talk about that in the next case, that have dealt with this question of public policy. In the interest of time, let me then move on to the second case, which I think is the most recent emerging from the Court of Appeal. And this is the case of National Cereals and Produce Board and ERAD Supplies and General Contractors and the Ethics and Anti-Corruption Commission. The fact that the Ethics and Anti-Corruption Commission was enjoined in this matter should already clue you into the fact that there was a hint or a suggestion that there had been fraud in inducing the award, or indeed in inducing the underlying contract that was the subject matter of the award. So turning then our minds to this second case, this is a domestic award, purely domestic, in terms of the fact that the award was delivered in Kenya. The interested party was actually, like I said, the Ethics and Anti-Corruption Commission. The supplier had, let me say, reach both in Kenya and outside of Kenya. The essence or the subject matter of the dispute was largely a commercial dispute for the supply of maize. I think it was 40,000 metric tons or something to the National Cereals and Produce Board, which is mandated by state, to essentially supply maize and its byproducts within Kenya. The underlying dispute had already been determined in terms of the award, and thankfully in this case there was no question of finality. There was a valid arbitration agreement, there was an arbitral process, and there was an application to the High Court, which is the court under Section 10 of the Arbitration Act 1995 that has jurisdiction to hear any questions of let me say, support or assistance required in an arbitral process, or indeed challenges to an arbitral process. So the High Court has initial jurisdiction on such questions. So the judge in the High Court determined that there were no grounds, if you will, for setting aside under our Section 35, which largely mirrors both the model law at Article 34 and 36 and the New York Convention at Article 5. So the questions before the court, the High Court as it then was, were questions again around public policy, and also that the arbitrator had acted or determined matters outside of the scope of the reference. In other words, they acted ultra vires of the reference, and also that contrary to public policy, as I said, and that the award was induced by fraud. This application was dismissed by the High Court. This is way back in 2011, and the respondent then moved successfully to adopt the award as a judgment of the court, which they then did, and began to extract, if you will, damages arising from the underlying award. The interesting thing in this case, as I already mentioned when I said that the Ethics and Anti-Corruption Commission was an interested party, is that separately, one of the parties, who is the appellant in this case, had instituted criminal proceedings against the three directors of the respondent company. And those were running in concurrence. So there was a multiplicity of actions, if you will, both on a civil channel and on a criminal channel arising from this particular contract. So, of course, the application to the Court of Appeal was from the decision of the High Court, which, according to the appellant, had not fully directed its mind to all the questions before it, and had, in fact, in addition to doing that, acted outside of the scope. So fully directing its mind is really the questions of corruption, public policy, and the rest. The other question, and I think, unfortunately, the High Court may have considered these issues as one, possibly because of the evidence before them. There was also the question of acting outside of the scope. How? Because in the arbitral award, the arbitrator had given damages that were resulting from a contract whose party was not privy to the arbitration agreement between the parties who are now before the High Court first and then the Court of Appeal. And this essentially inflated, quote unquote, the damages that were then awarded to the ERAD, who was the respondent in the appeal. So questions around the questions before the Court of Appeal, and let me try to fast track it so I don't go too much into detail. Questions before the Court of Appeal were really around whether the High Court did not fully address its mind to the questions that had been raised in terms of the impropriety, fraud in the inducement, and the like. Whether in granting an award to a third party, so to speak, they had acted outside of their jurisdiction. And then, of course, this whole question around public policy that I say is quite common, certainly in our courts, whenever an award is challenged or whenever a party is seeking to have it set aside. So the language in which the councils, the various councils were addressing the court was whether it was necessary for the High Court to, in a sense, interfere with the process and decision of the award in order to protect the integrity of the judicial process. And the Supreme Court, in considering this question, the Court of Appeal in considering this question, had of necessity to look at how the Supreme Court in Kenya has defined what we call the four corners of public policy, and the role, if you will, of the courts beyond the High Court in arbitral processes, because technically it is the High Court that has jurisdiction pursuant to our Section 10 as either supporting the arbitral process, like I said, or challenging that arbitral process in one way or another. So the Supreme Court had in its decisions, and we have several decisions, there's new to aggravate, there's geochem, which, I'll put in the chat a little later if you want to take a look at those cases, had essentially limited the superior courts, and by that I mean the Court of Appeal and the Supreme Court, had limited their jurisdiction to situations where there was such grave misaction, if I can use that word, by the High Court that it was necessary then to remedy the injuries that may be suffered by the parties. So the questions then, as I move to the end, the questions before the Court of Appeal were whether, in fact, the Court of Appeal, number one, had jurisdiction to hear an appeal arising from a High Court decision on setting aside under Section 35, whether the award was contrary to Kenya's public policy and therefore should be set aside, whether the arbitrator exceeded their scope of jurisdiction under the reference, and finally, whether the additional evidence admitted by the Court of Appeal affected the enforceability of the award. This evidence was essentially introduced by the interested party in an attempt to show that there had been fraud in inducing the initial underlying contract between the parties. So in closing, the Court of Appeal made its decision on the basis of these four questions and determined that public policy is to some extent delineated by this framework that I've said we've popularly referred to as the four corners, and specifically under the two cases that I mentioned, the first step is acknowledging that we are pro-arbitration in Kenya. By Section 10 of our Act, we underscore that only the High Court can interfere, if you will, with an arbitral process by remedying any missteps by the tribunal, if you will. So Section 10 is a policy statement, if you will. So it does form the body of public policy in Kenya, emphasizing the finality of arbitral awards and, of course, limiting then courts' access to interfering unless they are called upon to do so out of necessity in terms of justice. So these four corners really are around the manifest disregard, if you will, of the law by the arbitral tribunal, the extent to which they acted outside of their scope. So based, in closing, on the evidence that the interested party had brought, which unfortunately, incidentally, had not been brought before the High Court at the time, and therefore it could not address its mind to that, then number one, the tribunal erred in its application of two different sections on which grounds that form the grounds of basis of setting aside. And number one is our Section 35(2)(a)(4), which is that an award falls or deals with an issue that was not within the contemplation of the reference, and that is in awarding a third party damages. And then secondly, under Section 35(2)(b)(2), which is the public policy question, then the claim before the court was in fact in conflict with the public policy of Kenya. And to that extent then, citing the two cases I've mentioned, New to Agrovet essentially said the High Court, where the High Court has stepped outside the Section 35 grounds, then the superior courts can step in. Geochem stated that the Court of Appeal only determines whether the High Court ought to have interrogated the award further or not, and to that extent, it will remit the award back for consideration. So in closing, and in terms of the misunderstanding or misapprehension by the High Court, the corners of public policy were closed in this way, that allegations of fraud and corruption, as much as they were a question for determination in the criminal courts, are in fact so serious and so grave as for the High Court to have directed their minds to it. Unfortunately, they didn't have the evidence at the time. So even just perhaps mentioning that that was happening would possibly have been sufficient, and then leaving it to the criminal courts to dispense with it, which, by the way, they did, and determined that there was no, in fact, criminal element in this case. But should the court nevertheless have acknowledged that there were those allegations and assertions that were nevertheless being dispensed with elsewhere, instead of simply not sort of interrogating those questions at all, or even acknowledging those questions. So these questions of alleged forged documentation, claims of non-delivery of the subject matter of the contract, benefit to a non-party who was not even privy to neither the subject matter contract or the underlying arbitration agreement, definitely violated public policy and also offended the economic interest and morality of the state. So now we have a new definition, if you will, within this four-corner framework of public policy. So I want to close there. I'm sure we'll have opportunity to interrogate this a little further, Barbara, but so that the rest of the speakers also have an opportunity to engage, let me pause there with enough food for thought for us to consider. Thank you.
Thank you so much, Jackie. And honestly, I think that has set the tone for us. With skills that we may need to be careful about going to next year. If you're bifurcating, how do you bifurcate? How do you ensure that you have closed the arbitration process effectively? The tests for public policy, how do we ensure that we are within the regime of public policy, if we may say that nothing offends public policy from our arbitral awards? And finally, how to make sure we stay within the scope of the powers and the duty imposed on us. Thank you so much, Jackie. I would like to call on Justice Abdallah Ngozi to take us to the Tanzanian experience. Welcome, Justice Abdallah. Over to you. Please note you have 15 minutes.
Thank you very much. I think you can hear me.
Yes, we can. Thank you, Judge.
Thank you very much. Now, good evening, ladies and gentlemen. It is my honor to be here and share my personal experience on landmark decisions on arbitration from the Tanzanian High Court this year. I actually serve at the High Court of Tanzania Commercial Division, and therefore I handle a lot of arbitration cases, and I couldn't do justice to analyze my own decision, but there is this one case, is one incident I should say, because there are three cases. All of them are related to the same dispute or to the same arbitral award. So there are three decisions. Two of them were made by myself, and one decision was made by my colleague. And when you take them together and consider them collectively, the only conclusion you get is that many legal practitioners in Tanzania have not yet current Arbitration Act of 2020 as opposed to the repealed Arbitration Act of 1931. So a legislation which survived for 89 years has left some long-lasting impacts or effects in the minds of the legal practitioners who are not able, I can say, to cope up or to accept the fact that the new law has substantially changed the arbitration practices in Tanzania. So this is a case between a company known as Canopies Company Limited versus TARURA, Tanzania Rural and Urban Roads Authority. This is a government body responsible for construction of rural roads. So they had a construction agreement, and this Canopies Limited was a contractor, and in the construction agreement they had an arbitration clause, and a dispute ensued in the course of performance of the construction agreement. And what happened is that they referred the matter to an arbitrator, and award was made. So the award was made to a large extent. To a large extent, it was made in favor of TARURA. And to some extent, maybe by 25%, it was made in favor of Canopies, the contractor. So the contractor, Canopies, was not happy with the arbitral award. So he sought to challenge that award before the High Court. So he filed an application in court. And that application was before me. That's the first application. What was he seeking? Unfortunately, to the lawyer who handled that matter, maybe I should preface this with the old position of the law. Under the repealed Arbitration Act of 1930, and a decision by the Court of Appeal of Tanzania, and under the decision by the Court of Appeal of Tanzania, in the case of Tanzania Cotton Marketing Board, the practice was that you couldn't initiate an application for enforcement or challenge of arbitral award until the arbitral award was filed in court. So a person or the arbitrator or the parties, either party, could just file the award in court. After the award being filed in court, then parties could come to seek for orders for enforcement, or would come to seek for orders for challenging the award. So that was the position under the old law. You file the award for the sake of filing, and once the court has accepted or received the award, then you bring your application, either enforcing it or challenging it. So that was the position under the Repealed Arbitration Act 1931 and the arbitration rules of 1957. Now, this lawyer for the contractor still had in mind the old position under the old law, that you make an application for filing, and once the court makes an order, that was his perception actually. Because even under the old law, it was not an application for filing. People were supposed just to file the award in court. And upon filing the award in court, the court would number the award as an application. And from there, they would seek the enforcement or challenge. And when they were seeking enforcement, there were three avenues there are three orders which could be sought. Three avenues for enforcement of an award. One, registration of the award. It's a summary procedure to have the award registered as a judgment and a decree of the court. Second, are different. When a person is seeking registration, it means he wants the award to be converted into a judgment of the court. And where a person is seeking recognition, he is simply seeking for the court to enforce the award without converting the award into a judgment, so that the award can still be available to be enforced in other jurisdictions and treaty arrangements, the New York Convention and the other bilateral or multilateral arrangements. But where a person is seeking enforcement by registration, it means the court will have to write a judgment converting the award into a judgment, so that subsequent to registration, anybody wishing to implement the award outside Tanzania would have to enforce the decision of the High Court. That is enforcement of a judgment of Tanzania in other jurisdictions where it will be foreign decision. So those are the two avenues. And the third avenue is by filing a suit or action at common law under the doctrine of obligation. So these three avenues, where they are under the repealed law, they are still here under the current law. Now, this particular lawyer for the contractor had a misconception between filing and registration. I repeat, filing of an award, which is merely the presentation or the presentment of the award before the court. When you bring the award to court, you have filed it. But registration is a distinct procedure other than filing, because registration, it means you are seeking conversion of the decision of the arbitrator of the award into a judgment and decree of the court. So this particular lawyer had a misconception. So he made an application for registration. Even his prayer was that he was praying before me for the court to register the arbitral award, which actually had been rendered against himself by 75%, and he was not happy with it. But by confusion, he believed that he was making an application for filing, so that subsequent to filing, he would commence an application for challenging the award. But what he did was making an application for registration of the award. And that application was before me. And then he made another application for challenging the same award. And that application was before Honorable Morris J., another judge in the same division of the High Court. And I was not aware, and the parties never told me that there is a petition for challenging the same award, which is before you, to be about to be registered. So what happened? When the case was called, this particular lawyer for the contractor orally prayed before me to have the award registered as a judgment of the court. Then I asked the government lawyer for Tarura, do you have any objection? He said, no, we don't object to it. So immediately, without much ado, I simply made a simple order, instant order. The arbitral award by Engineer XYZ in this matter is hereby registered for enforcement as a judgment and a decree of the court. So the matter was over before me. So subsequent to my order, the same parties appeared before another judge in the other petition, which is now seeking to challenge the same award which I had already registered as a judgment of the High Court. So when they appeared before Honorable Morris J., the problem which arose was that the court now was functus officio. A fellow judge has already recognized the award as a judgment of the High Court. How could the other judge set aside the same award which the other judge has already registered as a judgment of the High Court? And I should say one thing here. In arbitration law and in civil procedure in general, there is a concept of measure, or there is a doctrine of measure. Under the doctrine of measure, where a cause of action has been incorporated into a judgment of the court, the cause of action ceases to exist and is merged. It is combined with the judgment of the court. It is merged into the judgment of the court. So when you are now going to challenge, you are not going to challenge the independent cause of action. When you are going to enforce, you are not going to enforce the independent cause of action. You are going to enforce the judgment of the court. In arbitration law, upon an arbitral award being registered, the arbitral award ceases to exist and it emerges into the judgment of the court, the doctrine of measure. Once an award has been registered, remember, I'm talking about a registration, not a recognition, two different concepts. So when an award has been registered, the outcome is that the court has to enter judgment in terms of the award. So upon the judgment being registered, and a judgment in terms of the award being rendered by the court, the award ceases to exist and any rights, duties, obligations, grievances which were there under the award cannot be enforced as against the award. They will have to be enforced as against the order of the court. So when they appeared before Morris J now, the question was whether now he had the jurisdiction even to entertain that application, knowing that a fellow judge of the same court had already registered it, and therefore the award was no longer there. What was in place was the judgment of the High Court. And he's a fellow judge of the High Court, so he couldn't do anything than saying that he had no jurisdiction. So the petition challenging the award was dismissed because the judge had no jurisdiction. But remember, this particular lawyer, his intention had always been to challenge the award. So he was aggrieved and he had no remedy short. Because before me, he came to register an award against himself. He was shooting himself with the leg in the war. So, and I already registered it. And when he went before another judge to challenge the award, the court was functus officio, so it was dismissed. But mind you, his intention was all along to challenge the award. So he had to come before me again with an application for review, a decision which I gave last week, 5th December, between the same parties on review. He came to me and he was saying that there was an error apparent on the face of record. So I should vacate my earlier order registering the award. Why? Because he had intended to move the court for only filing for the purpose of challenging the award, not to have the award registered. And I asked, of course, in my ruling, whether that error of an advocate making an application for registration of the award, thinking that he was making an application for filing the award, confusing between registration and filing, whether that was an apparent error on the face of record for the purposes of review. This is because under the Civil Procedure Code, an application for review under Order 42 of the CPC of Tanzania and Section 78, an application for review, first of all, could only be pursued by a person who is aggrieved by the order or decree. So this guy was granted exactly what he had prayed for. Is he an aggrieved party to have the locus to initiate a review? That was one. Secondly, the error is a misconception of law on the party of the advocate. Is an error or misconception of law on the part of an advocate an error apparent on the face of record of the court? I refused to grant that application because I held that the error might have been there, but that error was not apparent on the face of record of the court. In my view, record of the court constitutes acts which are done by the court from the beginning of the case to the end of the case. That is proceedings, judgment, proceedings. You talk about drawn orders, decrees, anything which the court is doing. It must be an error which is committed by the court and which is aggrieving a part. So here the error had been committed by a party. The advocate had misconceived the law. So I said, no, this is not an error apparent on the face of a record of the court. It is maybe an error on your part as a lawyer. It is not a ground for review. So here you have a person who had misconceived the position of the law between the processes of filing an award, which simply means to present or to bring an award before the court, and the process of registration, which means conversion of the award into a judgment of the court. And he had simply prayed for registration, thinking he was praying for filing, and which is not there in the law. I refused to register, to review my decision. So here I find a person who has shot himself in the leg because his remedy now is to challenge either my decision before the Court of Appeal, Which decision he made? The decision registering the award following his own prayer, a prayer which was not resisted by the other side. Or he should challenge the decision of the other judge, Judge Morris, which refused to entertain an application for challenging the award because the judge was functus officio. So if he's challenging my decision before the Court of Appeal, a decision, I can say like a consent judgment, because both parties agreed and I just made an order, the chances are very slim. And if he challenges the decision of Morris J., it is the law that one judge cannot determine, cannot undo what another judge in the same court has done. So chances are very slim. If he is going to challenge my decision about not reviewing my decision, like I've told you, my grounds were that he is not a aggrieved person. Secondly, the error is not on the record of the court. The error is on the misconception by the advocate.
Thank you,
So
Judge.
this is a person who has misconceived the law between the old position of the law partly and the current position of the law partly, and he's left, I can say, in limbo, not knowing how to go along. But as I sum up, I'm making an observation that, which is, an honest observation that I think the problem here was misconception on the part of the advocate between the procedure under the repealed Arbitration Act and the procedure under the current Arbitration Act of 2020. And the advocate has ended up mixing up and maybe ruining the cause for his client. Because to me, I think he's tied up, or he's caught between, they say hard thing and he's caught between it.
Between a rock and a hard place. Thank you so much, Judge.
Precisely. That's the situation.
Asante sana, Judge.
So,
Na msalimie huyo kijana aliye nyuma yako.
Host, I'm now done. Thank you very much for this opportunity to share the experience. I'm always available, and thank you very much.
Thank you very much, Judge, and we appreciate the input and the lesson of what we need to do, especially as advocates representing clients, to be very aware of the changes in law and to make sure that we are able to advise our clients correctly and do them justice when we take up their cases. Now, without much ado, allow me to call on Anne Namara Musinguzi. Anne, I would kindly request that you take only 10 minutes in your presentation, and then we will go directly to Dr. Koyugi, who will then give us another 10 minutes of the discussion so that we can have more time for plenary. Over to you, Anne.
Thank you, Barbara. I request that I'm enabled to enable my video.
That will be done. Please proceed with the presentation nonetheless.
Okay. Thank you very much. So in Uganda, what has stood out this year is the principle of finality, the principle of non-court intervention, as is enshrined in Section 9 of our Arbitration and Conciliation Act, Cap 5. So the Court of Appeal has taken the lead in confirming the prior decisions of the Supreme Court in Mbale Resort and Babcon and in Rocco versus Hamid, that if there is nothing in the Arbitration Act that allows courts to intervene, then court is supposed to be out of bounds. So the leading cases on this have been the Vantage cases. I call them the Vantage cases because there are many. There are about 5 cases arising from Simba Properties and 5 others versus Vantage Mezzanine Fund. This is a case that has spanned over 3 years in the court systems, but also in the arbitration process. About 3 years ago, the case was lodged before court. Vantage had lent money to Simba Properties under what is called the mezzanine agreement. And so many properties had been mortgaged of Simba Properties, and also so many undertakings had been made in the company in respect to transfer of shares. So when there was breach and a dispute arose, Simba Properties went to court, and the issue was whether the arbitration agreement was valid, and the court said that the arbitration agreement was valid, and the matter was stayed. The civil suit was stayed, and the parties went to arbitration in London. The seat of arbitration was London. So the arbitration was concluded, Just a minute, let me turn on my video. So the arbitration was concluded, and the parties came to enforce. The successful party Vantage Mezzanine came to enforce in Uganda. And that is when all these sorts of applications started. So there were very many applications. The first was by the successful party. They lodged an application in the commercial court, and they sought a very unique remedy called the post-operative protection order. Now, under Section 6 of our Arbitration and Conciliation Act, what the courts can grant is an interim measure of protection before and during, to preserve before and during. Now, these ones came and sought a post-operative measure of protection to preserve the status quo pending the recognition and enforcement of the foreign award. And court also granted it pursuant to our Section 98. They invoked their inherent powers and granted it. So the respondent, the loser, went to the Court of Appeal and prayed for so many interim orders, an interim order of stay, prayed for a temporary injunction. He prayed for an application to file an appeal out of time. And this was what he was saying. He was saying that in the lower court, they did not rely on the Arbitration and Conciliation Act. These are not matters that are coming from the Arbitration and Conciliation Act. So court can intervene in as much as they want. And courts in all about 5 or so cases of Vantage disagreed. The Court of Appeal disagreed and said that whereas there were some unique orders granted, like the post-operative protective measures, this did not change the fact that these were disputes arising from the Arbitration and Conciliation Act. So all the applications of Vantage relating to that were dismissed. There were some that a single judge of the Court of Appeal had upheld. There was a temporary injunction that had been granted, and the Court of Appeal, the full bench rejected it. So the principle that the Court of Appeal has rung loud and clear this year in Uganda is that where the parties have agreed to arbitrate, there is limited court intervention. Courts can only intervene as provided for in our Arbitration and Conciliation Act, Cap 5. So those are the 5 Vantage cases that emphasize the doctrine of finality as we knew it from Mbale Resort and from also Rocco and Amid. The other case that was interesting this year, it was a case that came from Kenya, KIU, Kampala International University versus Housing Finance Kenya. So in this case, these 2 parties had entered into a contract. It was a loan to do with loans. Housing Finance Kenya gave out some money to Kampala International University to construct in Kenya. So there were the loan was over $10,000, $15,000, and Housing Finance gave out about 11.3, and Kampala International University said that the balance was to be syndicated with other financial institutions, which was not done. But also, Housing Finance said that the money to be disbursed was dependent on completion. So you complete a stage, and then you present an interim payment of certificate, and then they pay you. They actually don't pay you; they pay the contractor. They were not supposed to pay Kampala International University. So there was a dispute because Kampala International University said not all the money was disbursed, and Housing Finance Kenya said no, but all the money was disbursed in accordance with the work that had been done. So the arbitrator found in favor of Housing Finance Kenya, who by that time had assigned their rights to Housing Finance Uganda. So he found in favor of Housing Finance Kenya and said, yes, there was a breach of the loan obligations by Kampala International University. But then he also found that the high interest rates had been charged by Housing Finance. And so there was a set-off. Because Kampala International University had a counterclaim, there was a set-off to the extent that Housing Finance had charged unconscionable interest rates. So this matter went for enforcement before the Kenyan court, and the Kenyan court upheld part of the award to actually and said there were 2 running applications: enforcement and setting aside by Kampala International University. So the Kenyan court in Milani set aside half of the award, a bit of the award, on grounds that what the arbitration governed was not exactly what the arbitrator awarded, because the arbitration was in respect to how much money was supposed to be given to KIU, Kampala International University, and in how many installments. Now, the part of how this loan was to be paid or default was not governed by the arbitration clause. It was governed by the loan agreements that did not have an arbitration clause. So to the extent that the arbitrator acted outside the scope of his authority, the award was set aside. And then Housing Finance applied for recognition and enforcement of their part that had been upheld in Kenya, and it was granted. Then they came to Uganda and applied under, because we are signatory to the New York Convention, they applied for recognition and enforcement of the foreign award. And our courts made an interesting distinction between the foreign award as granted by the arbitrator and the foreign judgment arising from the foreign award as granted by the court in Milani. And court said that they are not bound by the foreign judgment arising from the foreign award. Rather, they are bound by the foreign award as granted by the arbitrator. And they said, according to our laws in Uganda, because also KIU had put in an application to set aside on grounds of public policy, the ground being that in Kenya, part of the award had been set aside. And now here in Uganda, Housing Finance is applying for full recognition and enforcement. And our court said they're not bound by the foreign judgment arising from the foreign award. They are bound by the foreign award as was given by the seat of arbitration. And the grounds for refusing to enforce an award, a foreign award, are very clear in our Article 5, in the Article 5 of the New York Convention, to which we are signatory. And there were the applicants, Kampala International University, did not prove any of those grounds. So merely because the court in Kenya set aside half that award, it did not mean that the court in Uganda was bound to follow what the court in Kenya had said. So it was recognized and it was enforced as a foreign award. There was nothing to stop it from being recognized and enforced as a foreign award. The matter is on appeal. We shall see what the Court of Appeal will say. Another interesting case that came out from Uganda this year was the case on costs. There was always an issue. There is a High Court decision of Katamba Magala, that said that where the arbitrator was functus official, then they couldn't open up the award and grant costs. And it went on to say that any aggrieved party then would go to our registrar in the High Court for the granting of those costs. And this decision of Rocco versus Palmarina said the reverse, and they said that if you haven't made a case for costs before an arbitrator, then you are stopped from going to the High Court to make a case for costs. So in this case, the arbitrator had rendered their award and no application as to costs had been made. So there was no application for an additional award. Nothing was brought to the attention of the arbitrator. And they went to the court, to the High Court for enforcement. And there was an issue of costs. And the court said, no, the issue of costs lies with the arbitrator. So the arbitrator is supposed to give a decision on costs. If they hadn't done so, you would have asked for an additional award, which was not done. So in that instant case, they were stopped, and the law now is very clear. Yes, Barbara, I can see the time. I'm winding up. The law is very clear that if the arbitrator, you don't pay for costs, and neither do you bring it to the attention of the arbitrator that they did not award costs, then you are stopped from going to a higher court to claim for the costs. And finally, the courts have been very emphatic on not setting aside awards under our Section 34. They have come out strongly to say that if you don't meet any of those grounds, the award is enforced. Public policy is something that the courts have rejected. Like Jackie said, it's now a magic wand in the hands of every person who feels they don't have a ground. They'll say public policy, and it is very amorphous. No one knows what it is. The courts have tried to define what it is, something injurious to the public, something so against every manner of value to the public. And the courts have said, no, it may be amorphous, but it is not a magic wand. In our Constitution of Uganda, we have what we call Article 126(2)(e), where justice shall be administered without any regard to technicalities. So public policy had become like a magic wand, had become like Article 126(2)(e) with everyone waving. But the courts in Solcon, in the case in Solcon, in UETCL versus Solcon, rejected the argument of public policy and actually said that it was a disguised appeal, and rejected the public policy and refused to open up the award and enforced it. The courts in China, in the China engineering case, rejected the argument of public policy on grounds of res judicata and said that the matter before the arbitrator had not been decided upon in a previous arbitration with similar facts. The matter before the arbitrator was something to do with the retention from construction contracts, which had not been the case in the first arbitration. So public policy was rejected. And then very finally, court has clarified on appointing authority. There was a gap after the amendment of our Arbitration and Conciliation Act, which made our Center for Arbitration and Dispute Resolution a department in the Ministry of Government. So there was a gap on who the appointing authority should be, and the Arbitration Act defines an appointing authority as someone that has been recognized as such by the Minister of Justice. And so because we have our International Center for Arbitration and Mediation in Kampala, where the parties have failed to agree on how an arbitrator should be appointed, where the seat is Uganda, then the courts have come out clearly to clarify that then the appointing authority as named should be the one to carry out the appointment. So the key takeaways is that court is very emphatic on finality. Court is very emphatic on non-court intervention where parties have chosen arbitration. Thank you, Barbara.
Thank you so much, Anne. And interesting that you say that public policy is not a magic wand. I think we do need to sit down and look at the two different cases that you've mentioned, together with the case that was mentioned by Jackie on costs not being included in the award, therefore not being final and therefore being fatal to the arbitration process, and seeing whether we can have a policy discussion on that. Next online is Dr. Koyugi. Dr. Koyugi, we invite you to please make your presentation. Thank you very much.
Thank you so much, Barbara. Good evening, colleagues. I want to share with you one case that was adjudicated before Tanzanian courts late last year. This is the case of Oilcom Tanzania Limited versus Oryx Energy Tanzania Limited. Now, very briefly, in this case, there was a framework agreement between these oil marketing companies. Now, under the framework agreement, there were some underpinning smaller agreements that in totality provided for mandatory arbitration of any dispute that would arise under these agreements. Now, a dispute broke out between Oilcom and Oryx regarding an alleged breach of the framework agreement and, of course, the underpinning performance agreements. Now, this was a high-stakes case, given that the amount of the claim was running into hundreds of millions of US dollars, and a counterclaim in similar fashion running to well over 10 million US dollars. It was also a high-stakes case in the sense that the arbitral proceedings were riddled with some what I would call guerrilla tactics, some underhanded tactics as well. Each party was undertaking surveillance and counter-surveillance on each other. There were allegations of wiretapping and all that stuff, and trailing. They were trailing arbitrators. They were trailing the executives of each company in an effort to ensure that they are not undercut or there are no shady deals which the arbitrators would cut with either party. Now, in November 2023, a final award was handed down, which directed that Oilcom should be paid 132 million US dollars by Oryx, and also an additional 20 million as general damages for breach of contract. So in totality, their final award handed to Oilcom in excess of $150 million. Now, the next step was the filing of the award, in which case the arbitral tribunal secretary wrote to the registrar of the High Court to receive and register the final award. Now, that kicked off a storm. Oryx, as fate would have it, petitioned the High Court to set aside the award on a number of grounds. Some of these grounds, just briefly, relates to an alleged improper composition of the tribunal. There was an allegation that some of the members of the tribunal had relationships with the either party. Another ground related to an alleged lack of jurisdiction. I will come to that shortly. Another alleged ground for pushing for setting aside of the arbitral award relates to the allegation that the award had not yet become final and binding. Of course, the underpinning argument here was that there were motions which were pending before the Court of Appeal. And in this sense, that rendered the award not to be final and binding. So some of the issues that came out in this matter, one was whether there was indeed justifiable doubt regarding the independence and the impartiality of one arbitrator, Professor Musa Juma Assad. The allegation here was that Professor Assad was privy to a project which one of the parties had subcontracted to another party. So he was hired by the subcontractor to provide some technical services. So there was an allegation that in essence rendered Professor Assad to be lacking the necessary level of independence and impartiality. Now, the other issue that cropped up was whether the arbitrators handed down, they had jurisdiction to hand down an award outside the prescribed statutory time limits. Under Tanzanian law, an arbitrator is required to hand down an award within three months from the date the arbitrator enters into the reference. So this was an award that was handed down well after 3 years had elapsed. So the question was whether they had jurisdiction to deliver the award outside the statutory time limits without the benefit of an extension of time. And the other issue that cropped up was whether some two arbitrators out of three had the authority, they had the necessary qualifications to sit as arbitrators because they were not duly accredited. They were not duly accredited to provide arbitration services. Well, under Tanzanian law, as a matter of mandatory law, an arbitrator must be registered by a government institution to deliver arbitration services. Now, here's a case where two arbitrators out of three, it is argued they didn't have accreditation certificates. Now, the High Court navigated this matter in very deftly and cautiously, of course, and in a manner that was meant to preserve the integrity and efficacy of arbitration. Firstly, the High Court ruled that it was functus officio regarding the question whether Professor Musa Juma Assad had the required level of independence and impartiality to be part of the arbitral tribunal members. Why? Because previously the question had been taken up before the tribunal, where one of the parties was moving the tribunal to cause Professor Assad to recuse himself on the same reasons, and he refused to recuse himself. And then this matter was escalated to the High Court, where the court ruled that there was no valid grounds to compel professor to recuse himself, because for all intents and purposes, the relationship that existed was trivial and could not justify removal from the tribunal. So on that matter, the court ruled that it was already functus official because the matter had already been determined before the High Court. The other ruling was that the High Court ruled that the question as to whether the arbitrators had the necessary qualifications, that is to say, whether they were duly accredited to provide arbitration services, was not raised at the earliest opportunity. So the court reasoned that the petitioner was required to bring up the issue before the arbitral tribunal, and the arbitral tribunal was required to make a ruling regarding whether one or two members had the required accreditation certificates. Now, if the petitioner didn't do that in a timely fashion, the High Court reasoned that that amounted to a waiver of the right to object to the qualification or suitability of the arbitrator on account of lack of an accreditation certificate. Regarding the allegation that the arbitral award had not become final and binding because there were some matters which were pending before the Court of Appeal, the High Court ruled that allegation did not constitute a good ground to suspend the registration and enforcement of the arbitral award. And the court, in fact, was emphatic that seeking to suspend the registration and enforcement of the award on that reason amounted to a deliberate abuse of the court process. Now that's the snapshot. Now, what lessons can we draw from this case? Now, first, you can discern that the courts have been reluctant to interfere in arbitration proceedings, especially on account of trivial excuses. So that's what we can learn from that. The second lesson that we can learn from that decision is that the grounds to petition for setting aside of the award should actually arise from the face of the record of the arbitral proceedings. They cannot be generated outside the record of the arbitral proceedings. And the other lesson that we can draw from that decision is that the challenge to the qualification of an arbitrator, perhaps on account of an alleged lack of independence or impartiality, should be raised at the earliest opportunity. And in this case, should have been raised before the arbitral tribunal. So if a party sits on his rights to challenge the suitability or the qualification of an arbitrator, and then turns around to challenge that after the final award has been handed down, then it would be taken that the party has actually waived the right to challenge that arbitrator. Maybe I can, if you still have time, I can look at another case. Now, Barbara, the second case relates to Jitegeme. Sorry, can I proceed? I can see you speaking, Barbara. Can I proceed?
You have 3 minutes.
Oh, really? Yeah, I'll try to take it fast enough. Now, the second case relates to Jitegeme Trading Company Limited versus Allied Transport Agent Company Limited. Now in this case, the parties had a contract which provided for a tiered dispute resolution clause. So in the event of a dispute, the parties were required to first attempt to resolve the disputes amicably. If amicable settlement could not be achieved, the parties had the option to appoint an expert. And the dispute resolution clause required the parties to do so within 7 days. If they fail to appoint one within 7 days, then there would be an arbitral institution, in this case, the Tanzania Institute of Arbitrators, which should do so on their behalf. Now, once the expert hands down a decision, which would be a determination, and the other parties aggrieved, he can now escalate the dispute to arbitration. Now, what happened in this case is that the parties could not agree on who should be appointed as the expert. So the potential claimant would propose a name to the respondent, and perhaps the respondent, being hell-bent to derail the proceedings, would reject every name that would be proposed by the claimant. But of course, in return, the respondent would not come forth with a counter proposal. So there was this back and forth, and then the potential claimant decided to move the arbitral institution to appoint an arbitrator.
That's one. Hello.
I think I still have my 2 more minutes.
Yes, please.
Yes. So the arbitral institution appointed an arbitrator who was of course rejected by the respondent, and then there would be claimant petition the court to assist in the appointment of an arbitrator. Now the court declined by saying that the parties were bound to comply with the letters and spirit of the tiered dispute resolution clause. They were required to follow the agreement as set out in the dispute resolution clause: amicable dispute settlement, then an expert determination, then an arbitration. Perhaps I can end it there as for now.
Thank you so much, Dr. Koyugi. And I like the fact that you stopped at something that probably we as drafters need to really think about on the multi-tiered dispute resolution clauses and how effective they are or how useful they are to parties whenever they have to give them effect. So guys, once again, thank you very much for staying with us, and thank you to the panelists. I think it has been a brilliant lesson for all of us. We have learned a lot from Kenya, Tanzania, and Uganda. And I invite us, if there's anyone with a question, to please raise up their hand so that we can select you to ask your question. I see that there was a question on the chat that has already been answered by Justice Gonzi. So if there's any other question, please do feel free to raise your hand, and then we will pick you up on that. And maybe as colleagues are still thinking of their questions, Jackie, I wonder if you're still with us and if you heard about the Pearl Marina case that Anne Namara mentioned, and I think it was the Magara case as well, where the issue of granting of costs, which seems to be similar to the SAS Sogea case, was determined quite differently. I wonder if you have any thoughts about that.
Thank you, Barbara. I think the reason they were determined differently is because of the respective actions of the arbitrators in those particular instances. I think what was quite distinct about the arbitrator in the SAS Sogea matter was essentially not addressing the question and leaving it to the determination of a body or persons outside of the tribunal. So to that extent, then, that was the death knell, if you will, on the question of finality of the award, and hence the decision then to say if the arbitrator hasn't dealt with it, then the partial award cannot in fact be a partial award because it is not final. I think if the arbitrator had attempted perhaps to address the question of costs and done it in a way that was then challenged by the parties, it would have led to a different decision, possibly by the courts in assessing whether to set aside the award or whether to recognize and enforce the award. So I think the distinguishing feature in the case that I was looking at was really the whole question of what did the arbitrator do in terms of what they were expected to do, or what did the arbitrator not do in respect of what they were supposed to do. I think that is the significant distinction then of the Sogea case.
Thank you so much, Jackie. And over to you on how you think the courts should address the conflicting decisions between PAL and Magara.
And what is very interesting is that they're from the same court, the commercial division, two different cases. And the court in PAL Marina, because the Magala case was brought to their attention, they tried to distinguish it and said that in Magala's case, the arbitration had been concluded by the time the arbitrator was asked to open up the award and deal and decide on that issue. Whereas in the PAL Marina case, that was not the case. There was no distinction actually because they are the same facts. And I would agree with the court in PAL Marina that should be the position, because under our Arbitration and Conciliation Act, the arbitrator has power to rule on and determine fees and expenses of the tribunal. So we need maybe the Court of Appeal to come out steadfast on that if the matter ever reaches there, because the actual position of the law is that a registrar of the High Court does not have power to award costs arising from an arbitration. So we would need a higher court to bring that harmony, because that is the position of the law. The arbitrator has the powers to determine the issue of costs. If they don't, then the party is stopped from ever bringing up that issue.
Thank you. And Otim, I see your hand up. Please do raise the question.
Yes. Good evening, everybody.
Good evening.
My question is in relation to where there is a borderline relationship between, let's say, a contract of employment, because in Uganda, our laws exclude arbitration. I don't know other jurisdictions exclude arbitration for employment cases. Yeah. So what happens if, let's say, the person had a different contract, maybe a contract of service with the same company, thereupon arose a claim for maybe some work he had done, and then it went on and continued when he got the contract for employment. How then do the arbitrators handle that kind of situation? Do they only handle the situation where it tackles the claims under the contract for service and then leave out the employment bit, or we go under Article 126 so that all matters are concluded there? And if both parties agree, anyway. Thank you. That's my question.
Thank you, team. I think the question is clear. What jurisdiction does the arbitrator have for matters of employment, where in the first instance there was a consultancy and then the contract was thereafter turned into an employment contract and a labor dispute arose? As I leave the panelists to ponder over the question, Ivan, you have your hand up. Please raise a question. Please keep it to a minimum of 1 minute. Over to you, Ivan.
Oh, thank you very much. My question relates to what Justice Gonzi, if I got his name, talked about earlier, and whether the same applies to Uganda. The word or language used under Section 35 of the Arbitration and Conciliation Act is recognition. He talked about the difference between filing and registration, and it seems to just say shall apply to court in writing. Is that a formal application, say chamber summons, or I can just write and I attach the record of the arbitration? So anyone, maybe Anne, a practitioner in Uganda, or Jackie from experience in Kenya, since I believe the own citral model is also in Kenya, can answer that.
Thank you, Ivan. we head over to the panelists for your responses. I'll start with you, Dr. Koyugi, and then Justice Gonzi, if you're there, followed by Anne, and then followed by Jackie. Thank you, Dr. Koyugi.
Yeah, thank you, Barbara. Now, the first question relates to whether an arbitrator who has been clothed with the jurisdiction, perhaps in a contract of service, can as well go ahead and determine a dispute regarding a contract for service. I think the answer is straightforward. Arbitrator must operate within the scope of his mandate. If the authority to undertake arbitration arises from the contract of service, then he must confine himself within those parameters. He cannot overreach himself and proceed to determining disputes regarding contracts for service, like subcontracts or contract, like an independent contract, maybe that of an independent contractor, if that falls outside the parameters of his authority. Now, the second question was addressed to Dr. Mheshimiwa Jaji Gonzi. I'm afraid I didn't get it. If you may jog my memory, please, Barbara.
Not a challenge at all. The question was on the framing of the two acts, that's the Act of Kenya and the Act of Uganda, on Section 35(1) on recognition and enforcement, which simply says that an applicant shall apply in writing to court. They were seeking to distinguish the difference between how registration is then facilitated. I think that would be, if it's a foreign award, I'm sure in Kenya would be under the Foreign Judgments Enforcement Act. So they just wanted to understand clearly how the process is in Tanzania to be able to distinguish it from the Kenyan and Ugandan laws.
For the case of Tanzania, the law talks about recognition and enforcement. Now, in principle, to kickstart the process, say in the case of a foreign award, the arbitral tribunal or its agent would forward the award to the registrar of the High Court so that it could be filed. That's the first process. I think Mheshimiwa Jaji Gonzi alluded to that. And then the next process, of course, would be a notice to show cause, which would be issued by the High Court to the parties to show cause as to why the award should not be registered as a decree of the High Court and to be enforced as such. And then the parties would appear to show cause, and then it is at that point in time that the award would be open to any challenge after it has been filed. Yeah. So in short, that's how it happens. Yeah. Okay. Now, how do you do that? There was a question as to how do you do that? In Tanzania, you can you apply to the High Court to have the award filed by way of a letter. The tribunal would write a letter to the registrar. Now, if there is a challenge, perhaps there is a challenge seeking to have the award set aside, or to have the award remitted back to the tribunal for reconsideration, or if there are clerical errors. Now, it depends. If it is an application petition to set aside an award, you do so by way of a petition. Yeah.
Okay. Thank you, Dr. Koyugi. Justice Gonzi, do you have any further input?
Yeah, my input is that the procedure which my colleague Dr. Koyugi has explained is exactly what is done during registration of the award, and it is regulated by Regulation 51, Sub-Regulation 4 of GN number 146 of 2021. That is registration. Now, when it comes to recognition, which is different from registration, recognition is done by petition, because recognition is governed by Section 83 of the Arbitration Act, and the regulation is 63. So you have to file a petition, like Dr. Koyugi has said. So I would rather say that it depends on how the mode of enforcement which you choose to apply. If you decide to go for registration, then it's a letter. And if you decide to go by recognition, it is a petition. And any application whatsoever under the Arbitration Act, it is done by petition. That's what the Arbitration Act of Tanzania says. Thank you.
Thank you very much. And over to you to distinguish for us the Ugandan practice and also answer the labor dispute question.
Thank you, Barbara. In respect to the labor dispute, our act is very clear. The Employment Act and the Employment Settlement of Labor Disputes Act, that employment matters are not arbitrable. So if employment matters are not arbitrable, like my colleagues have said, then the arbitrator does not have the jurisdiction to handle them. So they cannot be subject to an arbitration process. If there was a consultancy and the consultancy is what it is, a consultancy, and it is not an employment issue, then there it can be subject to arbitration as long as you can sever the consultancy from the employment latter bit of it, then there it can be arbitrable. But an employment matter, the arbitrator doesn't have jurisdiction. And then about the recognition and enforcement of an award, Ivan has cited Section 35 that says the application has to be in writing. The rules made under the Arbitration and Conciliation Act, specifically Rule 13, provide that all applications to the court, and it makes it mandatory that all applications to the court shall be by way of summons in chambers. So when you seek to register and recognize and enforce your award, you move court by way of summons in chambers. That is according to our CAP 5. Thank you.
Thank you. And Jackie, over to you.
Okay, so similar to the experiences in both Tanzania and Uganda, our Section 35 requirements in terms of recognition and enforcement are really a question of civil procedure, as you earlier said, and reflecting then the spirit of both the New York Convention and the UNCITRAL model law, which simply requires that a copy or a duly authenticated original of the arbitral award are presented and submitted to the registrar. And secondly, the underlying arbitration agreement, similarly, the original authenticated or a certified copy of that. Added to that, of course, if it's an international arbitration and was rendered in a different language, then a duly certified copy as well in the English language of the award. Those will be, if you will, the required documents that must be submitted to the registrar, along with then the application that is sort of the overarching application that's made to the courts for recognition of the award. So process and the administrative language may differ, but I think the spirit is really just to make sure that the award and the underlying agreement are submitted, and of course then that any timelines are adhered to as well. I can't off the top of my head remember what the specific timeline is, but if I do remember, then I will raise it before we close this evening.
Thank you so much, Jackie. I'm not sure if it was 30 days, or is it 60 days? I'll also check and confirm. Since there are no more questions, I will allow the panelists with sincere gratitude to give us their parting shots. Once again, I will begin with Justice Ngozi, followed by Dr. Koyugi, and then Anne, and finally Jackie. Just 2 minutes of your parting shots. Justice Ngozi is still with us. Justice Gonzi. Okay, Dr. Koyugi, maybe you can go first.
Thanks a lot, Barbara. And thanks, colleagues, for this opportunity to talk matters arbitration. I would only encourage that webinars of this sort should be happening quite often, because even if you retrace the history and growth of arbitration, one of the impetus which aided the growth of arbitration were workshops and conferences and trainings of this sort. So thank you so much for organizing such an eventful thing like this. Otherwise, see you next time. Cheers.
Asante sana. Justice Gonzi, if you're back with us. If not, Anne, over to you.
Thank you very much, Barbara, for excellently moderating. I would like to thank my fellow panelists for a job well done. And I thank LLP Dispute Settlement Hub for this opportunity. And as we've had this evening, the overarching thing that is cutting across all countries is that arbitration, once the parties choose to arbitrate, then courts respect that decision and they will only intervene as guided by the different laws. So as we pursue arbitration, we should remember that court intervention is very, very limited and courts uphold all the intentions of the parties to arbitrate. Thank you very much and looking forward to more discussions like this.
Thank you, Anne. Weatherly Mnonga. Over to you, Jackie.
Thank you, Barbara. Maybe just to reiterate 4 things that have come through in this conversation. Number one, a pathological arbitration agreement will, of course, inevitably lead to a challenge on the grounds of jurisdiction. So really important as we're drafting these arbitration clauses to be very mindful of what it is we are actually submitting to in terms of a reference to arbitration. Secondly, a failure on the part of the arbitrator to confirm their subject matter jurisdiction with the parties will inevitably lead to a challenge on Section 35 in Kenya, grounds for setting aside. A failure to deliver once you have that subject matter jurisdiction, a failure to deliver fully with finality responses or determinations that parties can literally take to the bank will, of course, lead to a Section 35 challenge in terms of setting aside. And finally, on the question of public policy, I really am encouraged, certainly by what I see in Kenya in terms of trying to define that scope of what is largely an amorphous question of morality and justice. And I think I see it reflected also in the comparative jurisdiction across the region. So I am encouraged by the stance that East Africa is taking then to position certainly our jurisdictions as favorable for the continued conduct of arbitration. Thank you.
Thank you very much, Jackie. I don't know whether Justice Gonzi is back with us. Okay, thank you all. Thank you to our distinguished speakers and to ALP Dispute Settlement Hub for having us over to discuss this question on what the leading cases on arbitration in East Africa will influence our practice for 2026. Once again, a special appreciation does go to our distinguished speakers for sharing their experiences and practical perspectives on arbitration trends and landmark decisions that are shaping the region. We hope that today's discussion has provided for you valuable takeaways for your practice and deepened your understanding of the evolving arbitration landscape in East Africa. Please do stay connected with the Dispute Settlement Hub for more webinars, as they will keep updating on their website and on their social media platforms. Asanteni sana. As they say in Uganda, tweanziza, tweanzege. Asanteni sana. Thank you and have a lovely evening.
Thank you too.